Hello, and welcome to another one of our short teach-ins here at the Tenant Farmers Association. My name is George Dunn. I'm the Chief Executive of the Tenant Farmers Association, and this teach-in is part of a series which we use to shine a light on topical issues that are being faced by our members every day of the week. And it's the sort of issues that our team of expert advisors also get involved with. It's part of our growing YouTube library, in which you will see webinars and important industry updates and other materials. So don't forget to let us know what you think about this teaching in the comments below. And if you found it useful, why don't you subscribe to our channel, and then you will be updated with new material when we publish it on our YouTube channel. Today, I'm delighted to say we've got Caroline Squire, who's one of our expert rural surveyors here at the TFA, and she's going to be highlighting steps to take where your landlord isn't undertaking repairs that they should be doing. But before we get to Caroline, I just want to say a big thank you to Roythorn Solicitors. They are sponsoring our 2025 virtual teaching sessions. And for those of you who don't know, Roythorns is a national law firm steeped in agriculture with over 90 years of experience, and they advise landlords, landowners, and tenants alike. The lawyers are very active in farm tenancy policy forums. So whether it's about succession under the Agricultural Holdings Act or a new farm business tenancy, a dispute with your landlord, a share farming agreement, or even a collaborative natural capital agreement, Roythorns is there to help and assist. So moving on to today's teaching, the heading is, if your landlord isn't undertaking repairs on your holding, here are some steps you can take. So this is being recorded in the autumn of 2025. So everything we cover today is correct at the time of recording. So for any specific advice on your individual circumstances, we do recommend you call the TFA for expert one-to-one advice with one of our advisors, just like Caroline. And if you join as a member, we'll be able to keep you up to speed with things as they develop. So let me now introduce you to Caroline Squire, who, as I say, is one of our expert rural surveyors here at the TFA, and she's going to take us through our teaching for today. Caroline, over to you.
Thank you, George. So both Agricultural Holdings Act tenancies and Farm Business tenancies will set out how repairing obligations are divided between the landlord and the tenant within the tenancy agreement. The tenancy agreement may specifically itemize which parts of the holding each party is responsible for, or it may refer repairs to a statutory instrument, such as the model clauses for agriculture, of which there are a number of versions due to updates being made over the years. So if the tenancy agreement does refer to the model clauses, it's important to check which version of the model clauses apply so that tenants are clear on theirs and their landlord's responsibilities. A problem a lot of our members come across at some stage is that fixed equipment, which the landlord is noted as being responsible for repairing, is in disrepair, and the landlord hasn't undertaken the repairs, and TFA advisors are often asked what can be done in this situation. So for both AHA and FBT tenants, the first port of call should be writing to the landlord to inform them of the required repairs and asking for them to undertake them. If the written request falls on deaf ears, the next port of call is to check the tenancy agreement to see whether there are any specific provisions allowing the tenant to serve notice requiring the landlord to undertake repairs which are their responsibility within a certain time frame, and allowing that if the landlord then doesn't undertake the repairs, the tenant can carry out the repairs themselves and then recover the full or reasonable cost from the landlord. If there is such a clause, I would generally recommend flagging this with the landlord to bring it to their attention that you are aware that you can take action should the landlord not comply with the notice, and threatening to serve notice should the landlord not undertake the repairs. If the threats also don't work, I would then suggest following through with the threat and serving a notice to repair, ensuring that it's served in accordance with the requirements as set out within the tenancy agreement in order that it's valid and can be relied upon, and a TFA advisor can help with this. If the landlord then doesn't do the work within the required time frame, the tenant can then do the work themselves, paying for it in full. And if the landlord doesn't willingly reimburse the tenant afterwards, in accordance with the terms of the tenancy, the tenant will then have to pursue the debt through the court, which is why it's really important that a notice to repair is served correctly so that the tenant can then rely on it if they then have to go through the court to recover the money. And one thing to point out is that it's worth checking whether the landlord also has the right to serve a notice to repair on the tenant for any tenant's outstanding repairs. And if they do, I would bear in mind that if the tenant serves a notice to repair on the landlord could well serve one back on the tenant for any of the tenant's outstanding repairs. And like this isn't necessarily a reason to not serve notice, unless perhaps there were a lot of outstanding tenants repairs, but it's certainly something to be aware of. If we could have the next slide, please. So if the tenancy agreement is an AHA and it has no specific provisions within it for serving a notice to repair, the latest version of the model clauses for agriculture will kick in which there are provisions for the tenant to be able to serve a notice to repair, giving the landlord 3 months to undertake the work. And if the landlord doesn't comply, the tenant can then undertake the work themselves and recover the reasonable cost, unless the landlord was to serve a counter notice contesting their liability to do the work. And likewise, if it's an AHA or an FBT tenancy in which the model clauses are incorporated into the agreement by a term of the tenancy agreement, the notice to repair provisions within the model clauses will apply. It is important that the tenant knows which version of the model clauses apply to their tenancy agreement, because under earlier versions of the model clauses, some cost recovery is capped. So, for example, the 1973 model clauses, as amended by the 1988 regulations, cap cost recovery for replacements at a sum equal to the rent of the holding for that year, or £2,000, whichever is lower. So £2,000 is now, of course, likely to be the smaller sum, and this means that replacements which cost more than £2,000, the tenant would only be able to recover £2,000 yearly until the full reasonable cost was recovered. If the tenancy agreement doesn't have specific provisions allowing the tenant to serve a notice to repair, or if the model clauses do not apply to the tenancy agreement, then the tenant unfortunately wouldn't have the recourse of serving a notice to repair. Having the ability to serve a notice to repair is something I always flag when checking through new FBT agreements. 9 times out of 10, the landlord will have the ability to serve notice to repair on the tenant. So I always suggest tenants ask for a mirror clause, allowing them to serve notice to repair on the landlord, so that they have some comeback and ability to force repairs, knowing that the model clauses don't automatically apply to FBTs in the same way that they do to AHAs. An alternative option, which is available to all tenants, regardless of the tenancy terms, is to apply to court for a decree of specific performance to force the landlord to perform his repairing obligations. Specific performance is a discretionary remedy and is only granted where damages would not be an adequate remedy and where, under all circumstances, it would be considered just to be granted. A decree of specific performance will only be granted if the court is convinced that it can control compliance with the decree, and this will normally require a full particularised schedule of what works need to be done. However, it's important to note that an application to court for specific performance is very costly, and where the outstanding repairs carry significant cost, it may be appropriate to apply for specific performance, but perhaps not for less costly repairs. And tenants should always seek advice from the TFA as to their options if they do find themselves in a situation where the landlord is shirking on their repairing obligations.
Great, thanks, Caroline. That's really, really useful. I'm just going to throw a few questions at you following on what you've had to say. So let's take a scenario. I'm a tenant farmer, and my landlord is responsible to repair and replace roofs. I've got a building on the farm that needs to have a new roof, and I've checked my agreement, and the 2015 model clauses apply. So I can serve a notice to repair on the landlord here. But the problem is that the work's going to cost me something like 20 grand. And I really can't afford to do the work if the landlord doesn't comply with the notice. So what should I do?
So unfortunately, the notice to repair provisions in the 2015 model clauses do require the tenant to undertake and pay for the work and then recover the cost from the landlord afterwards. And this is a problem where the outstanding repairs are expensive and the tenant can't afford to carry them out himself. I would still suggest flagging to the landlord the fact that you're able to serve a notice to repair and threatening to serve a notice to repair if the landlord refuses to undertake the repairs by a certain date. You could then follow through if it doesn't have the desired effect. You could then follow through with serving a notice to repair, as the landlord won't necessarily know that you aren't able to pay for the work and follow through with it. However, if the landlord still doesn't complete the works following a notice to repair being served, unfortunately, there is little which can be done if the tenant can't afford to follow through and complete the works themselves. And likewise, a specific performance claim could be equally or more costly than doing the works. So that may be out of reach as a solution as well, unfortunately.
Okay, so let's say I crack on and serve my notice to repair in accordance with the tenancy terms, and then undertake the work and then seek to recover the cost from the landlord. Can I charge interest on that debt?
So I appreciate it may take some time to recover the costs from the landlord, either by agreement or through court, but unfortunately, no, it's not possible to charge interest on the debt.
Well, that's a straightforward answer. So my last question on this scenario then, so can I just go ahead and do the outstanding repair work myself and then just deduct the cost from the next rent payment?
So tenants should under no circumstance ever do that unless the correct procedure is followed, i.e. serving a notice to repair where the tenancy agreement allows for this. The tenant has no legal right to recover the cost from the landlord if they take it upon themselves to do the work themselves, unless the landlord has agreed that in writing. The majority of tenancy agreements also stipulate that rent must be paid in full without deduction or set off, meaning that even if money was owed for repairs or otherwise, the tenant is prohibited from deducting what is owed from the rent, and failure to pay the rent in full could then lead to other problems like a notice to pay for an AHA tenant or forfeiture proceedings for an FBT tenant.
Thanks, Caroline. Some really good advice there. We'll have to leave that there for today. If you've got any other questions and you're watching this and you've got some issues around your individual position and you're not yet a member of the TFA, then you can join. And currently, the cost of membership is good value for money. It's only just £299 per year. And it gives you access to dedicated advice, information, and support from experts in our team, just like Caroline. So for more information about the TFA, how we can support all farmers in England and Wales who don't own the land that they use for agriculture, go to our website, which is www.tfa.org.uk, and you'll find information there about our calendar events, our latest news, and also how to join if you're not already a member. So we really do hope that you found this teaching useful. And as I said, it's part of a growing YouTube library of material which you can access and enjoy. So let us know in the comments what you thought of this teaching video. And don't forget to like and subscribe to the channel so you don't miss out on any new content as we post it. So many thanks again to Roy Thorns for their sponsorship of our virtual program this year in 2025. And we look forward to seeing you again soon. All the very best. Goodbye.